Welcome to the Kentucky Auto Accident Podcast. Louisville attorney Jim Desmond has been handling injury cases related to traffic accidents for over 20 years. Jim will provide valuable information to help you and your family. He wants you to understand the important issues you need to know when it comes to handling car accidents and motorcycle wrecks in Kentucky. There's a lot riding on this, so let's get started. Welcome to episode 7 of the Kentucky Auto Accident Podcast, featuring attorney Jim Desmond of the Desmond Law Office here in Louisville. My name is Jim Ray. I'm a non-attorney spokesperson, but the nice thing is, if you're listening today, you actually get a bonus. You're going to listen to two attorneys talk about topics related to automobile accidents that may actually interest you here. So we're going to introduce Jim Desmond. Welcome back to episode 7. And his guest today is attorney Scott Scheynost, who does workers' compensation across the state of Kentucky, who's going to talk a little bit about how sometimes an auto accident claim can also involve a workers' comp claim and kind of the nuances of how that gets handled. Hey, Jim, welcome.
Thank you, Jim. This episode, we're going to concentrate pretty much, well, I won't say exclusively, but largely on workers' compensation law. One of the reasons I'm kind of glad that Jim Ray suggested bringing Scott in on this one is because of the fact that I don't know much about workers' compensation. I don't want to know much about workers' compensation. It is a very vast area. I try to stick to car wrecks as much as possible. But what we'll find out here in a second is, unfortunately, they tend to overlay a little bit. To give you a little bit of background, though, Scott's not somebody I just met. Scott I've worked with probably 2 or 3 years. I'll give him calls relatively often about how do we handle this workers' comp case? Is it workers' comp? What's my person's right in regard to workers' comp? So this is somebody who I do trust that, yes, if I got injured tomorrow and I was on the job, I would call in a heartbeat and say, hey, let's have you handle that part. So with that being said, Scott, welcome. Thank you for coming in, taking the time to do this.
Happy to be here. Look forward to talking about all this stuff today.
Let's jump into the one that because you and I just dealt with each other in the last week, and it's kind of a good example. Of course, all I do is car wrecks, and I had somebody call me, and they were a former employee, a former client, an employee of TARC 3. They were rear-ended by another vehicle, okay, and it was a good impact because, obviously we're dealing with a bus. We actually threw them forward, and we had hospital and emergency room treatment, and then they were following up after that. Well, the first question I had, because I had to call Scott and say, okay, is this a workers' comp case in addition to the car wreck, because of the fact that, again, they're working at the time for TARC, so if that's the case, normally, well, let me take a step back. Normally, I would be getting the medical bills and lost wages paid through my client's own car insurance, the no-fault carrier. That's what we talked about before in the previous episodes. Since this is an employee on the job driving a bus for their company, workers' comp should apply. And that's where Scott came into play. So, Scott, I threw that question to you, and of course, you told me it was workers' comp. Take me from there a little bit.
Sure. The big thing there is that they are actually on the job when it happened. Generally, when you're on the job, when an accident happens, it's going to be work-related. And I'm talking about an accident involving a car. When that occurs, workers' comp is what we call primary. They're the primary insurance source here. They're the primary source of payment for medical bills and lost wages. They will pay before any other source.
Let me cut you off right there. Let's talk about that. You said about primary source for medical bills. Of course, no-fault coverage is limited to $10,000 per person unless additional PIP has been bought. Okay?
Correct.
Workers' comp, as I understand it, there's no limit, is there?
In Kentucky, there's no limit on medical expenses, no.
Okay. There's another, you said, there sounded like a but there.
Well, some people have health insurance, and I've seen people come into my office where they've been turning into their own health insurance when actually workers' comp would be the party that's responsible for it. So folks may have several different types of insurance available with an accident, but if you happen at work, workers' comp's usually primary to all those other insurances, whether or not you have car insurance, PIP, whether or not you have health insurance or even sickness and accident insurance policy. So workers' comp is usually the primary insurance policy available to people to get these benefits paid for. In fact, all your other insurance policies usually have a provision in them that workers' comp will pay before they do.
Gotcha. Let me ask you a question, though, because with no fault coverage, of course, I can say, hey, why don't you call this chiropractor down the street or go to the immediate care center? I always get the impression that workers' comp has a right to kind of control your treatment. Is that wrong?
That's a pretty common misconception in Kentucky about being able to direct your treatment to specific doctors. In fact, 2 or 3 times a week, I'll have somebody call me up and say, my boss told me I had to go to this specific doctor. In Kentucky, we are what is called a choice of physician state, which means you get to pick the doctor, chiropractor, medical provider that you want to treat with. There's some limits to that. For instance, if your company participates in what's called a managed healthcare system, which is like an HMO for workers' comp, you've got to go to one of the providers in that system. They can't tell you which one to go to, but you've got to go to one of those providers. My experience is that's pretty rare when somebody's actually in a managed care system. So most of the time, somebody's going to be able to pick a doctor on their own that they want to go to. And in fact, probably my best legal advice as a workers' comp attorney is that you need to pick your doctor, not let your company or the insurance company pick it. Some doctors have a different concept about how to treat injured workers. Your family physician, your GP, somebody that you know is generally going to want to make sure that you're okay, that you get treated well, that you recover faster than maybe a doctor that the company sends you to. There's a reason the company sends you to a specific doctor, and that's generally cost containment. And the way you contain costs is you don't get as much medical treatment, you don't get it as fast, and there's several other things that can happen down the road, for instance, in giving you impairment ratings and determining whether or not you can go back to work. And generally, company doctors are going to be what I call more conservative, and they're not going to treat you the same generally as your family doctor, who just wants to get you better.
So let me go back here for a second and take a step back. If somebody called me and they were in a car wreck, I always say, usually I want you to try to go to the doctor within the first 3 to 4 days after a wreck if you're hurting, okay? And part of the reason I have to do that, of course, is because we've got to create a paper trail, okay? If I don't want people to treat that aren't hurt, but obviously if it's not documented in medical records, it looks like they weren't hurt, okay? Yeah. So on workers' comp, what's the first step? If somebody has been injured, and we're going to stick to the car accident because it's the easiest one, right. They're driving down the road, they're dropping off something for their employer, they're in a car accident. I guess, first of all, you're going to tell them, yes, if you need to go to the hospital, go to the hospital. They don't have to wait and get approval from anybody, is what I'm hearing, correct?
That's correct. And that's the first thing you need to do is make sure you're okay. Stop the bleeding, make sure the bone's set, all that kind of stuff. Make sure you're in good shape. You won't be able to do anything else if you don't.
What about any duties to notify the employer?
In Kentucky, you have an immediate duty to tell your supervisor, somebody in a managerial capacity, that you've been injured at work. And that's so they can make an investigation to determine the extent of your injuries and if it was actually work-related. That's a statutorily mandated provision. You have to give them notice as soon as practical about it. Sometimes you run into situations where you may be hurt and you may not realize it was work-related down the road. For instance, you could develop carpal tunnel and your hand's bothering you, something like that. And you might not really know that was a work-related problem until several months later. Usually in a car accident, though, you're going to know that the injury is due to the car accident. So get the medical treatment, and right after that, call your boss up, call up human resources. If you can't get a hold of them for some reason, send them a certified mail letter that you were injured. But you need to let somebody know. It doesn't have to be in writing, but you do need to let them know that you've had a work-related injury as soon as possible. And if you don't, that can be used as a reason to deny you benefits later on.
Gotcha. And as a matter of fact, I guess I want to be clear on something that, there's 2 claims. So the car wreck happens, and if you're working at the time, there's 2 claims that happen immediately. So, for example, of course, I handle the third-party claim, which is, against the other person, okay, the person who hopefully is at fault. But the workers' comp claim really kicks in immediately, is what you're telling me, is that you have the right to get your medical bills and or lost wages paid by your employer immediately if you were working at the time of the accident.
That's correct. And a lot of times what happens is people have an injury that they recover from and don't have any permanent problems. Workers' comp pays for the medical treatment. Workers' comp pays for them being off work. But let's say they have a broken bone and it's set, and after a couple of weeks, the bone's okay, they're basically back to normal. At that point, really, the workers' comp benefits stop. There's no permanent injury. They're not going to get any money for that. They got the money for being off work. They had all their medical treatment paid for. They got mileage expense back for going back and forth to the doctors, all that stuff. But from that point, there's not any more money probably they're going to get from workers' comp. If there's no permanent problem, and there's a long definition about how we figure out if you have a permanent problem, but if there's no permanent problem, that's really all you're going to get from workers' comp. But you may still have a claim for pain and suffering for what you went through, which could be substantially more than all the money you got from workers' comp. That's really where you come in.
Right, but hold on, let's go back there for a second, because and you threw me off when you said pain and suffering. Because pain and suffering, of course, against the third party, the one who caused the wreck and such like that, and that's what I would be handling. As a matter of fact, to give you the process a little bit, sometimes what will happen is if there is a car wreck, and Scott and I have worked together before, basically he will take the workers' comp case, I will take the auto case, and they're kind of going along at the same time in conjunction with each other, because as long as we're getting the medical bills paid and such like that, they're kind of congruent. They go very nicely together. But to go back to something else you were saying, let's say there is a permanent impairment, okay? So I've got a client who's, let's say, a broken arm, and the mobility is never the same. The doctor's making it clear. Okay. I'm going to, of course, use that against the third party to, make a claim against their liability insurance and potentially the underinsured coverage that we talked about before. But you're saying in addition to that, there's a claim against the employer over and above the medical bills and the previous lost wages.
That's correct. That permanent disability, and there's a long, convoluted way that we determine this. It'd take about 3 hours to explain it, but the big thing to remember is if you have a permanent problem. If you have a permanent problem, that's probably going to result in a permanent impairment rating, and that's usually the key to getting additional money from workers' comp after you recover from your injury. The amount of money depends on several factors, generally how bad the injury is. The higher the impairment rating, the more money you make, how old you are, your educational level, your ability to go back to work. All those things influence how much money you get for the permanent disability. It influences how much you get. It influences how long you get it. But the main thing to remember is if you have a permanent problem, if you've got a limp from this, if you have a range of motion issue, if you can't use your arm or hands like you did before, if there's some kind of a permanent problem, you probably have an impairment rating. And even after you get done treating with the doctors, you're probably entitled to more money from workers' compensation. Again, there's a convoluted formula on how we determine that, but you're entitled to more money from workers' comp. Also, you're probably entitled to lifetime medical treatment for that from workers' comp.
Okay.
For instance, if you have a limp and you have to have a special shoe with a special device in it that keeps you from limping, those wear out over time. Well, guess what? After 2 or 3 years, workers' comp may have to buy another one. And after 2 or 3 years, they may have to buy another one. That can go on for the rest of your life.
I'm going to cut you off there because I want to make a point on something. Because you said it, and you especially made it clear to me with the lifetime part. I've told people before in prior episodes, I don't recommend you handle your own car wreck case just because I've seen it get more complicated with health insurance liens and such like that. Okay. What I'm hearing again on workers' comp, especially if there's a permanent impairment, it's complicated enough that if somebody gets to that point, you need to talk to an attorney. And again, because even the formula you're talking about, I've never had to calculate it. I've never calculated it. I will never calculate it. That's why I've got you to call, okay? But that's true. You're telling me, hey, I guess from what I'm hearing, if someone's injured on the job and they have a permanent, if their medical bills are paid and they don't have a permanent impairment, that's one thing. But if they've got any kind of permanency from this thing, it sounds like you almost don't have a choice. The law is complicated enough. You need to talk to a workers' comp attorney and somebody who does workers' comp regularly, correct?
I agree. That permanent problem results in a lot of other benefits that actually become very important to you. And you've got lifetime medical benefits. You also have a right to reopen your case. If you have to have another surgery 3 or 4 years down the road to fix a problem, and then you have additional problems from that, you may actually have a higher impairment rating. In Kentucky, you can reopen your case. And also we have a thing that's not really awarded a whole lot. It's called vocational rehabilitation, which means that if you can't go back to your regular job, you may be able to get retraining from your employer up to 52 weeks at another course, and your employer may have to pay for all your tuition, all your books, all your expenses to go back to school. And I've had cases where that's been $20,000 or $30,000 worth of extra expenses on top of that. You don't normally get that from PIP in automobile accidents, and it's not always common to get that in a workers' comp claim. But the bottom line is you probably need to talk to somebody that knows what might be available to you and knows whether or not your situation is something that needs to be pursued further. Workers' comp is different from one state to another. You may have a cousin in Illinois that knows exactly how much money they got for this injury 5 years ago. Well, that's not going to apply in Kentucky. For instance, in Indiana, you don't get lifetime benefits. Their benefits are a lot less. They're not as generous in Indiana as they are in Kentucky in a lot of aspects. Some states don't let you reopen your case. So workers' comp is different from one state to another, but there's a lot of extra benefits people don't seem to realize unless they've sat down and talked to an attorney that you might be able to get from workers' comp. Generally, the insurance company is not going to tell you about those extra benefits when they're talking about selling your case. They're going to say, we're going to give you this money. You might be waiving a lot of benefits that you don't even know you're waiving when you accept that settlement without talking to an attorney. Well,
and I'm going to emphasize 2 points that you just made. That should be clear, hopefully. The first several episodes we've talked a lot about in car wrecks that there's limits, and that's why I've pushed people to get uninsured and underinsured coverage because we don't know if the at-fault driver, that's the third-party claim, if the at-fault driver has enough insurance or they can pay your medical bills, whatever it might be. What I'm hearing on workers' comp is, I don't want to say it's limitless, but there's a lot more opportunities. There's not those same caps. There's not those smaller caps. So again, the need to talk to somebody who's a good qualified attorney who does it. And then the other thing I will say, it probably carries over to workers' comp. I don't know if you experience this as much. I always warn people in car wrecks that I say, be careful who you go to, because car wrecks are a very lucrative area of the law, and a lot of people dabble in it. So again, it sounds like with workers' comp, with how complicated it is, you want to go to somebody who really does understand this is not your typical area, and I've got to keep up to speed on it, because I know from a personal injury attorney standpoint, we get regular case updates, and it seems like something new is always coming out with workers' compensation law.
Well, it is, and they like to change the law about every 3 or 4 years. They changed some of the things substantially about 2 years ago in 2018. There's some legislation right now in front of the Kentucky legislature that might change some things around here in another 2 or 3 months. So it is a little bit more complicated. About every 4 years, it changes substantially. And again, the bottom line is probably talk to somebody that knows what they're talking about.
How long do they have to talk to somebody? Because, of course, in Kentucky with a car wreck, we know it's 2 years from the date of accident, and you can extend that, but I don't even like to talk to my clients about it. So let's say I've been injured on the job. They took care of everything. I'm 10 months into it. I think I have maybe a permanent impairment. Is that too late to talk to an attorney?
No, it's not. In Kentucky, for workers' comp claims that involve what we call a traumatic injury, where you've been hurt in a car accident, there's a 2-year statute of limitations. That begins to run from the date of the injury or 2 years from the last time you received temporary total disability benefits, which is money for being off work, whichever is later. So if somebody's been involved in an accident, they've had a surgery, they've probably been off work, and workers' comp's been paying them temporary total disability benefits. When those stop, they've got 2 years from that date to file a formal claim. At the same time, it doesn't hurt to talk to somebody sooner, because there's a lot of things we have to get to figure out what your case is worth. And to be honest with you, that's based on medical records and a lot of other things, and it can take several months to get those. So even though you've got 2 years, I think it's better if you go ahead and proceed to talk to somebody. You're probably going to have to talk to them about permanent disability anyhow. And what I also see in workers' comp is, even though workers' comp is responsible for medical treatment, anytime there's some substantial medical treatment, the insurance carrier usually doesn't want to pay for it. Usually they'll do things to try to get out of paying for that. They'll find a doctor somewhere that says you don't need it. And probably 60% of my cases that involve surgery also involve what we call a medical fee dispute, where we're fighting over whether or not somebody needs that treatment.
What do you do in that circumstance, though?
Well, generally, if we can't convince the insurance company that they're wrong, we will have to file a workers' compensation claim, and we will have to have the administrative law judge determine whether or not the medical treatment that's at dispute is reasonable and necessary for the person that was injured. In other words, we've got to have a judge decide whether or not the insurance company's got to pay for it. Probably 60% of my cases involve that. Now, it can be a lengthy process, 9 months to a year, to get that decision sometimes. A lot of times people have other sources of insurance that will be able to pay for it while we're arguing about it. For instance, their own health insurance. If it's turned down by workers' compensation, you can have it turned into your regular health insurance. Another thing, too, in a car accident is you have this PIP available for you. And again, if you've got this $10,000 out there, and some people have more, you might be able to convince the PIP carrier to pay for the medical treatment. And what happens then is that instead of the workers' comp carrier denying it, you just turn it into the PIP carrier, and they'll go ahead and pay for it. So the PIP benefits can actually help get your treatment sooner, and you can help that will also help you resolve your claim sooner too, because we really can't figure out how bad your permanent disability is until you get the medical treatment.
Gotcha. Grab a drink. Jim Ray is sitting here. He has a question, so I was going to let him jump in.
Well, one of the questions I've got is, you guys started off saying these are two separate claims going on at the same time, more or less.
That's correct, yeah.
Since the workers' comp is primary, does the decision in that case have any relevant impact on the automobile claim, Jim, that you're going to be pursuing on behalf of the same client?
Depends on what you mean by the decision. If the medical bills are related to the car wreck, then that's what's helping the car wreck claim. It's not, when you're talking about the decision, I think you're referring to like the administrative law judge saying, hey, is this related? So, I mean, it doesn't come into play. I've never seen it. Have you ever seen it that way? I've never had that come into play. Again, an insurance adjuster for the at-fault driver, they care about what the doctors say in the medical opinion. They don't really care about the determination by the judge.
Well, yeah, the at-fault driver doesn't really have any influence in the decisions in the workers' compensation claim. But what happens is the employer's insurance carrier generally is trying to prevent from the injured employee from having too much as far as medical expenses. So they're generally trying to reduce those costs. It's a cost containment effort on their part, and they'll do what they can to try to prevent surgeries from occurring and significant medical treatment like implants and stuff like that. So You're in an adversarial relationship with the workers' comp carrier a lot of times, well, most of the time. And I think a lot of people forget that their employer is paying for the benefits, but at some point, the employer's insurance carrier is going to decide that we don't want to pay for this. And you need to go in there with your eyes wide open. They're not really your friends. You're costing them money, and at some point, they're going to go ahead and try to reduce those costs.
Does the fact that you're involved help prevent that? Because, okay, on the car wreck claims, for example, I always hate when a client has gotten into it and started to negotiate some, because they've kind of set up a review where the supervisor's already looked at it. Everybody wants to be limited. Now I got to show why the first, analysis of this claim was wrong by the insurance company. So if you get involved in a case from day one, you say, okay, I think there's going to be a permanent impairment here. I can tell. And versus is somebody who waits 6 months to get you involved. I mean, do you have a better chance of keeping it out of, basically any kind of litigation over it?
Well, it helps to get in the middle of it sooner. Generally, what happens is there's a set of procedures that the workers' comp carrier has to follow to determine whether or not somebody needs medical treatment. And I don't want to get too complicated here, but a lot of that involves your medical records. If we're involved at the very beginning, we're usually monitoring your case. We're getting your medical records. We know what's going on. And if something comes up where there's a dispute, we've got those medical records available where we can either argue with the adjuster or we can send those to another expert and get another opinion relatively fast. Now, if you came in my office right now and said that you had a problem getting medical treatment, we'd have to get all those medical records. We'd have to get an expert. We'd have to figure out what's going on. And it just takes a process to get that. It can be several weeks, if not months long, to get all that information sometimes. So if you've got somebody involved at the beginning, it's a little bit easier to pull the trigger if you need them to help you in those situations. Whereas if you wait till you have a problem, you've got to call them, you've got to set up a meeting, you've got to get all the medical records together, and it takes a while to figure out what's going on with the case. You just can't go in and blindsided. A lot of times there's things going on in medical records that the client doesn't even know. So as an attorney, you've got to go back and you've got to do your due diligence and look at those records to figure out what's happening in order to help them. And it just takes a while to get ready to help somebody. You've got to get all the stuff in front of you.
On the car wreck cases, I want to pull something in that I see a common question because, of course, with no fault insurance, we don't have a choice. We have to use it. Okay. I've talked before in other episodes that basically anything that could be paid under no fault coverage, we don't have a right to recover from that fault party. That's what the law says. So the short story on that is everybody hates to use their own car insurance because they worry it's going to go up.
Right.
And again, as you were saying about workers' comp being primary, if it's a straight car wreck with no employer involved, no fault coverage is primary over health insurance and other sources. But my question to you is, because I know how some of my clients think, can they get fired if they use workers' comp? Because they're worried about their employer sitting there saying, hey, you're making me pay out this stuff. My medical bill or the insurance coverage cost is going to go up. And I see a lot of hesitation on that. So
yeah, well, you got to remember, workers' comp comes up in other situations other than car accidents. So this is actually a pretty common question. There's a specific law in Kentucky that prevents retaliation for filing a workers' compensation claim, and that's almost like a civil rights action, where someone is being discriminated against for something that's protected by statute. So if the employer comes up and say, we're firing you because you filed a workers' comp claim, that's probably a better case than the actual workers' comp claim, to be honest with you. And it's not in the Workers' Comp Act. That's, again, more of a separate type of action like civil rights. But that can actually be more lucrative, I guess, than the workers' comp claim itself. What happens is most employers are not that specific about why they're doing things. And you may be treated that way, but you've got to prove that's what happened. And the way you do that is you keep records of who says things to you, what's been done if your assignments change, your friends in the plant or the workspace. Hopefully they'll make notes about what's happening too. But most employers are not really that direct about it. What I found is the bigger employers generally understand how this works and generally don't have that kind of an attitude. It's the smaller shops where there might be 3 or 4 people working there.
Okay.
And the employer doesn't see that you have a broken back because nothing's bleeding, you don't have a cast on. They don't think that you're hurt. That can be a difficult situation sometimes, and sometimes you have to educate the employers on that.
The other question that you and I have dealt with over and over, and this is where I wear poor Scott's ear out and he has to give me free advice, is, does workers' comp apply? Because the issue, it sounds like it's easy. It sounds like, if you're in the scope of employment, workers' compensation should be primary. But again, the question always is, what is in the scope of employment? So it's a situation where, let's talk about that for a second. If I'm, let's go with, we've talked about this before, and let's talk about the parking lot case. So I work for one of the large companies in Louisville. I pulled into their parking lot. Somebody backs up into me, okay? And let's say we're a pedestrian. Let's say we're out of our car. We're walking into work to go to work. Would workers' comp be primary, or would we be looking just at the auto case?
Well, a lot of it depends on exactly what you're doing. For instance, if you haven't clocked in yet, okay? If you've clocked in, obviously it's workers' comp. Even if you're walking in somebody's parking lot other than your employer's, if they send you across the street to run an errand or something like that. But if you haven't clocked in, that's the gray area everybody always wonders about. The law essentially in Kentucky is workers' comp depends on the control the employer has over the parking lot. If you are at a company's parking lot and the company has exclusive control over that parking lot, you're at a big company, they have their own parking lot, they maintain it, they've got a gate you've got to go through to get into. Once you go through that gate, pretty much any injuries that occur on that parking lot are going to be work-related. So if you're at a company's parking lot that's controlled exclusively by the company, if you get out of your car and you slip on the ice, you hurt your head, that's actually a workers' comp injury. If you're walking across a parking lot and another employee hits you, that's a workers' comp injury.
And Scott, to break in, that is even before you've clocked in. You're on property, you're on premises, therefore comp may be applicable.
Correct. The big thing isn't whether or not you've clocked in on that. The big thing is the control the company exerts on the parking lot. So if they own the parking lot, if they control the parking lot, if they gate it off, then it's pretty clear that's going to be covered by workers' comp. The gray area occurs where there's other people on the parking lot. For instance, if you work in a shopping center for a retail store, if you're in that parking lot where everybody parks in it, and then you're walking from that parking lot into the store, there's a good chance that may not be work-related to you actually cross the threshold where the store owns it. Now, if the store tells you to park in specific parts of the parking lot, for instance, some of the big malls don't want employees to park in the general parking lot during the busy Christmas season. They make you park over in, the lot that's farthest away because the customers want to be closer. There is an argument then that they exerted control over where you parked at, and that might be work-related. But in general, if you're not required to park in a specific spot, and if the parking lot's a common parking lot with other businesses and other people using it, that may not be work-related. There's a lot of gray areas here, and again, it's probably good to talk to an attorney about it. But again, the control over the parking lot itself is the major factor.
And on that issue, it's funny, I'm talking to an attorney again because of the fact that when we were coming up with this example, I'm sitting here thinking, okay, let's go to a parking lot that's not controlled by the employer. Well, there's at least a question whether or not they're still within the scope of employment that workers' comp can apply. The no-fault coverage is going to come from the vehicle that came into contact with the pedestrian, okay? Right. And if it's not, again, controlled by the employer, then I think you could potentially look for med-pay coverage again under the premises liability policy, okay, with the
I agree with you, yeah.
So, but to go back to something else I wanted to pull out from that, because this is the fun part about workers' comp, right? So let's go back and say that you pulled in that parking lot, and again, and we'll use an extreme example to make a point. Another employee is just got off shift, and we think he was drinking or something else. So he's a drunk driver too, right?
Right.
So he hits you, okay, as a pedestrian, causes a pretty good injury. So we're not just talking about a knockdown on the ground or anything. So can I still make that claim against the employee who hit me, the drunk driver, or am I barred from that? Because that's another area that you and I know about, but go ahead and expand on that employer immunity.
If it was on a parking lot that was, again, controlled entirely by the employer, and let's take the drinking part of it out of the equation for a second, and you're on the company's parking lot and you're hit by another employee who's a fellow employee, Kentucky has what's called an exclusive remedy action, which means that, exclusive remedy law, which means that you cannot sue a fellow employee if it's workers' comp. So, with a person not drinking, that's pretty clear when it's on the company parking lot. You cannot sue them. You can only recover workers' compensation benefits. The drinking may be arguably something that takes it out of the scope of employment, and I think you might have an argument then to go against the other employee, but that's probably, again, going to be covered by the exclusive remedy provision in Kentucky, and I think you'd have a very hard time doing that. Now, the parking lot, again, at the shopping center, if you're hit by another employee that's off the clock, then that's probably something where you can pursue the action against a fellow employee. At some point, if you're driving down Dixie Highway and you get hit by somebody you work with at Ford Motor Company, over off Westport Road, that's not work related at all. So that's a third party action. But the fine line and all that, I think, is the control again over the parking lot. If it's workers' comp, then you're probably not going to be able to sue the other employee. If it is covered by workers' comp, then you're not going to be able to pursue that third party action.
So again, and part of what you're saying there, and I've always heard this as well, again, similar to no fault, we give up a lot of legal rights, in this case, the legal right against the employer, okay, in exchange for basically all these rights covered under the workers' comp statutes.
Right. Kentucky workers' comp is like no fault. You can actually opt out of it. I've yet to see somebody practice in 30 years that's opt out of either one of them, to be honest with you.
You wouldn't, and I deal with the opting out of the no fault, but that's because cab drivers are forced to do so.
Well, okay.
Yeah. But the workers' comp, I mean, what would there ever be a reason to opt out of workers' comp?
Probably if you're a high wage earner, there would be a reason because there's limits in the workers' comp system. And if you're a high wage earner and you've got enough insurance, sickness and accident, disability, and health insurance with minimal deductibles, workers' comp can be hard to deal with sometimes. And if you're a high wage earner, you wouldn't have to worry about what we call offsets for some of these benefits if you got it from workers' comp. So if you've got enough insurance, there may be an incentive to do that. And remember, when you agree to workers' comp, you're agreeing to waive that third-party liability because of the exclusive remedy. So if you waive workers' comp, then you can sue that fellow employee. Okay, if you're at a factory and somebody drops something on top of you, you can sue them.
Let me jump in for just a minute. We're going to wrap up in a few minutes, but I want to really kind of jump back into the scenario you just gave. If I am hit as a pedestrian on company property, then comp,
right,
ideally takes over.
Right.
What happens if we're both in our cars and somebody runs into my car, somebody T-bones me in the parking lot? Does Jim Desmond still have the opportunity to go after the property damage and the other issues outside of comp? I mean, you had said, well, if the company has controlling interest, where does that break down?
Well, if you're in the vehicle and it's on the company's property, I think that's still workers' comp. Even stepping out of the vehicle is not that big a distinction. The distinction is really who controls the property. So if you're on the property and you're actually inside the vehicle, that's still going to be covered by workers' comp, and it's going to have to be a third party outside of it, somebody else that's driving that's not employed by the company before you can actually pursue that action against them.
So in that case, would workers' comp be responsible for my mechanic getting my car replaced or repaired?
Yeah, I'm sorry. Workers' comp only pays for your personal injuries, medical treatment, disabilities, things like that. Workers' comp doesn't do anything with property damage, which would be another source of insurance, another coverage that you would have to look at. And I'll be honest with you, that's something I'm going to have to ask Jim about. I've never really had that situation where property damage comes up between two fellow employees. I would assume that property damage would still be covered by the respective insurance companies of the employees, but I really don't know. I've never looked at that.
Yeah, I've never had it either, but I can't see how they could get out of that. And again, I don't think we'd have to look at the statute, but
the exclusive remedies, I understand, it just applies to personal injuries.
Okay, that makes sense. I appreciate you clarifying that. Guys, that's a wrap for episode 7 of the Kentucky Auto Accident Podcast. Jim Desmond, I want to thank you for your time here. If somebody needs to contact you in regards to an automobile accident, what's the best way for them to get a hold of you?
I prefer my cell phone, which is 502-609-7657, or they can contact me off the website if they want, which is attorneydesmond.com.
And Scott Scheynost, how can they get in touch with you if they have a workers' comp claim?
My office number is 502-937-5287. I have a website too. You have to be able to spell Scheynost, which is the hard part, SCHEYNOSTLAW.com. So attorneydesmond.com and ScheynostLaw.com. I want to thank everybody for listening, and we're going to pick this conversation back up in episode 8, which is coming up here in about 2 weeks, and we're going to go through some very specific examples of different scenarios that happen and how the interplay between an automobile claim, automobile accident claim, and workers' comp can work together, and sometimes when they don't. So once again, thank you very much for listening, and that's a wrap for the Kentucky Auto Accident Podcast. That's it for this episode of the Kentucky Auto Accident Podcast. Jim Desmond will be back in 2 weeks to provide information you need to know related to car accidents and motorcycle wrecks in Kentucky.
Until then, check out AttorneyDesmond.com. You can also follow him on Facebook at Attorney James Desmond. Drive safely and please remember to buckle up.